Start para. The defendant number 2 in suit number 354 of 2013 filed this appeal against judgment and decree dated 17/1/2019 passed by learned trial court in that suit, whereby learned trial court decreed the suit for eviction on the ground of subletting, arrears of rent and non-user. Full stop para. It is case of the plaintiffs that they are the landlords of room number 1, Dwarka Prasad Dubey Chawl, known as K.S. Nagar, Mumbai, of which defendant number 1 is monthly tenant. Full stop para. It is contention of the plaintiffs that suit premises was let out to defendant number 1 for residential purpose. Full stop. Defendant number 1 is very irregular in paying monthly rent. Full stop. He has paid rent of the suit premises up to December 1997 and thereafter he stopped paying rent. Full stop. Plaintiffs issued demand notice, but despite of issuance of notice, defendant number 1 has not paid rent of the suit premises. Full stop. Defendant number 1 has unlawfully sublet the suit premises to defendant number 2, and at present defendant number 2 is in exclusive use and occupation of the same. Full stop. Defendant number 1 permanently shifted to his native place in UP and he does not require the suit premises. Full stop. Therefore, on these grounds, plaintiffs prayed for recovery of possession of the suit premises from defendants. Hence, this suit. Full stop para. The defendant number 1 served by RPAD Wide Exhibit 16 but not appeared in the suit, and therefore suit proceeded ex parte against the defendant number 1. The defendant number 2 resisted the suit by filing written statement at Exhibit 17. Full stop. According to him, false, bogus and frivolous suit is filed by the plaintiffs. Full stop. Defendant number 2 has contended that he is residing in the suit premises since 1981. Full stop. Tenancy of the suit premises was jointly acquired by him and defendant number 2 is his uncle. Full stop. Therefore, rent receipt was issued in the name of defendant number 1. Full stop. The defendant number 1 shifted to his native place, and being nephew, defendant number 2 is using the suit premises. Full stop. The defendant number 2 denied that defendant number 1 has unlawfully sublet the suit premises to him. Full stop. He has further denied that defendant number 1 is irregular and defaulter in paying monthly rent. Full stop. He denied that demand notice was served to defendant number 1 at his native place in Uttar Pradesh. Full stop. It is further contended that suit premises is in Mumbai city, but with deceitful intention, plaintiffs sent demand notice in Uttar Pradesh, which is not at all served on defendant number 1. Full stop. In order to grab the suit premises, plaintiffs have filed this false and bogus suit. Full stop. Therefore, defendant number 2 has prayed for dismissal of the suit. Full stop para. Mr. Bhange, the learned advocate for appellant, argued that the learned trial court wrongly held that there is subletting. Full stop. In fact, the suit premises was let out jointly to defendant number 1 and 2. Full stop. Defendant number 1 is a uncle of defendant number 2 and being karta of family, issued rent receipt in his name by previous landlord for his convenience, which aspect has not been considered by the learned trial court and, therefore, committed error in not considering the same, full stop. The learned trial court failed to consider that defendant numbers 1 and 2 are residing in the suit premises from inception of tenancy and defendant number 1 shifted to his native place in the year 1982 due to his ill health and old age prior to plaintiff become the landlord of the chawl with prior permission of landlord and also press document of 1973, but the learned trial court did not consider the same, full stop. He further argued that the ground of non-user and subletting are hit by law of limitation. Stop.